The introductions to international criminal law. It covers introductions to the international criminal law, the core international crimes, historical development and evolutions, case law and precedents, current challenges in international criminal law, Nuremberg and Tokyo trials, genocide conventions, challenges in prosecuting international crimes, Filartiga and Pinochet cases, crimes against humanity and genocide, International Criminal Court, the ICC, piracy and hostage taking. International criminal law is a branch of public international law that seeks to address the most serious offenses that affect the international community. It establishes the legal framework to prosecute individuals responsible for international crimes such as genocide, crimes against humanity, war crimes, and the crime of aggressions. The foundations of international criminal law are embedded in numerous treaties, customary international law, and the statutes of international tribunals, such as the International Criminal Court, ICC. One of the most significant legal frameworks underpinning international criminal law is the Rome Statutes of 1998, which established the ICC. This statute outlines the jurisdiction of the ICC over the most heinous crimes, providing a legal mechanisms for holding individuals accountable for these offenses. The Rome Statute specifically mentions 4 core international crimes. Genocides. It is defined under Article 6 of the Rome Statute. Genocide involves acts committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group. Key case law includes the Prosecutor versus Akayesu, where the International Criminal Tribunal for Rwanda, ICTR, prosecuted individuals for acts of genocide during the Rwandan genocide. Crimes against humanity, as detailed in Article 7, crimes against humanity consists of widespread or systematic attacks directed against civilians. These include murder, enslavement, torture, and rape. The Nuremberg trial post-World War II were among the first to address crimes against humanity on a large scale. War crimes, as provided under Article 8 of the Rome Statute, it defines war crimes as serious violations of the laws and customs applicable in armed conflicts. Examples include deliberately attacking civilians or deploying prohibited weapons such as chemical agents. War crimes were also prosecuted at the International Criminal Tribunal of the former Yugoslavia, the ICTY, which handled cases involving ethnic cleansing during the Bosnian War. The crime of aggressions under Article 8 bis. The crime of aggression refers to the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state in contraventions of the United Nations Charter. The evolutions of international criminal law can be traced back to the aftermath of World War II, with the establishment of the Nuremberg and Tokyo tribunals. These tribunals were the first to hold individuals personally accountable for atrocities committed during the war. They set the precedent for individual criminal responsibility, which is now a cornerstone of modern international criminal law. In more recent times, ad hoc tribunals such as the ICTY and ICTR have been established to prosecute individuals for international crimes committed during conflicts in the Balkans and Rwanda. These tribunals, established by the United Nations Security Council, demonstrated the international community's commitment to justice and accountability. The case law and precedents, there are numerous landmark cases which have shaped the development of international criminal law. One of those is Prosecutor versus Tadic, the ICTY. This case set a precedent for the interpretations of war crimes and crimes against humanity in non-international armed conflicts. Prosecutor versus John Paul Akeyesu in ICTR, the first convictions for genocide, establishing a judicial understanding of the crime's elements. Prosecutor versus Thomas Lubanga Dilo in the ICC, the first verdict delivered by the ICC dealing with the conscriptions of child soldiers during the conflict in the Democratic Republic of Congo. Despite the advances made in the prosecution of international crimes, significant challenges remain. One of the most prominent issues is the lack of universal jurisdictions. While the ICC provides a mechanisms for prosecuting international crimes, its jurisdiction is limited to states that have ratified the Rome Statute. This limitation creates jurisdictional gaps, as certain states, including major powers like the United States, China, and Russia, have not submitted to the ICC's jurisdictions. Additionally, enforcement of international criminal law relies heavily on state cooperations. The ICC, unlike domestic courts, does not have its own police force to arrest individuals accused of international crimes. This means that the effectiveness of international criminal law often hinges on the willingness of states to apprehend and extradite suspects. International criminal law serves as a critical tool for addressing the gravest breaches of international peace and security. The Rome Statute and other international legal instruments provide the foundations for holding individuals accountable for genocide, crimes against humanity, war crimes, and crime of aggressions. Despite facing challenges such as limited jurisdictions and reliance on state cooperations, international criminal law remains a vital component of the international legal order, promoting justice and deterring future atrocities. The document begins by discussing Nuremberg International Military Tribunal. It is established in 1945 to try individuals accused of war crimes, crimes against humanity, and crimes against peace. The tribunal's charges elicited many protests about victors' justice because of questions about whether the alleged acts had been specifically criminalized and whether individuals could be held accountable for their actions. The tribunal's judgment, however, laid the foundations for the development of international criminal law, recognizing that individuals, not just states, could be held responsible for the most serious violations of international law. The Tokyo Tribunal was established in 1946 to try individuals accused of war crimes and crimes against humanity committed by Japan during World War II. The Tokyo Tribunal followed a similar approach to the Nuremberg Tribunal, establishing the criminality of certain acts under international law. The Genocide Conventions adopted by the United Nations General Assembly in 1948. The convention defines genocide as any of the following acts committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destructions in whole or in part, imposing measures intended to prevent birth within the group, forcibly transferring children of the group to another group. The International Criminal Court (ICC) it was established in 2002 to prosecute individuals accused of genocide, crimes against humanity, war crimes, and crimes of aggressions. The ICC is a court of last resort, meaning that it can only prosecute individuals if national courts are unwilling or unable to do so. The challenges faced in prosecuting international crimes, which includes the lack of comprehensive international criminal court, issue of retroactive applications of the law, and the tensions between state sovereignty and the need for accountability. It highlights the significant progress made in international criminal law, which includes the establishment of the International Criminal Court (ICC), the increasing use of universal jurisdiction by national courts to prosecute international crimes. It also emphasizes the growing role of NGOs in human rights issues and the continued pursuit of justice for international crimes. The evolutions of international criminal law, it focuses on crimes against humanity and genocide. It examines the legal frameworks, the case law, and the challenges associated with prosecuting these crimes. The Nuremberg Tribunal and the Tokyo trials was the first time that crimes against humanity and waging aggressive war were defined as international crimes for which individuals could be held personally responsible. The tribunal charges elicited many protests about Victor's justice because of questions about whether the alleged acts had been specifically criminalized and whether individuals could be held accountable for their actions. The tribunal's judgment, however, laid the foundations for the development of international criminal law as it sees today, recognizing that individuals could also be held responsible for the most serious violations of international law. And the Tokyo tribunals followed a similar approach, establishing the criminality of certain acts under international law. The issue of retrospective applications of the law arises when individuals are prosecuted for crimes that were not criminalized at the time they were committed. This can raise questions about whether it is fair to punish individuals for acts that were not considered crimes at the time. The tensions between state sovereignty and the need for accountability is a recurring theme in the development of international criminal law. Traditionally, states have been reluctant to interfere in the internal affairs of other states and have been protective of their own sovereignty. The need to hold individuals accountable for the most serious international crimes, however, requires states to cooperate and to allow international institutions to investigate and prosecute crimes. The Filartiga case and Pinochet cases are examples of how domestic courts have played a crucial role in advancing the principle of international human rights and criminal law. In the Filartiga case, the United States court held that the Alien Tort Claims Act (ATCA) could be used to prosecute individuals for torture committed outside the US. The court found that the torture was a violation of customary international law and that the ATCA provided a basis for jurisdiction over such crime. In the Pinochet case, a British court held that the former Chilean dictator, Augusto Pinochet, could be extradited to Spain to face charges of torture and other crimes against humanity. The court found that Pinochet was not immune from prosecutions for crimes committed while he was in office, and that the principle of universal jurisdiction allowed for the prosecution of such crimes. One aspect of the universal principle of jurisdictions acknowledges that certain activities undertaken by both states and individuals necessitate an authority vested in all community members to punish these acts wherever or whenever they may occur, even in the absence of a direct link between the state and the parties or the acts in questions. Throughout the earlier discussions, we have noted the evolutions of international law concerning these questions and the areas where they overlap with more traditional areas of the law. Individuals typically do not represent a subject of international law, although the scope of human rights law has expanded over the past 60 years. The international criminal law forms a subcategory of this human rights regime. Not every human rights norm falls into the category of ICL or international criminal law. Certain crimes, however, have such international significance that the community of nations has felt compelled to make all those, including sitting heads of state, who commit them directly subject to international law. The Charter of the Nuremberg International Military Tribunal first defined crimes against humanity and waging aggressive war as international crimes, for which individuals could have personal, individual criminal responsibility. The term genocide had not yet entered into the general usage. The charges elicited many protests about victors' justice. Nonetheless, the precedent set by Nuremberg and its counterpart at Tokyo firmly established the principle that individuals could be held directly responsible for certain acts, presumably as categories of crime that permit an exercise of universal jurisdictions, in which all states may exercise their jurisdictions in prosecuting a perpetrator, regardless of where these crimes occurred. For the crimes against humanity, like many other terms, ordinary usage often misuses the idea of crimes against humanity. In popular parlance, it has come to mean anything atrocious committed on a large scale. This does not reflect either the original meaning or the contemporary technical legal one. The terms originated in the preamble to the 1907 Hague Conventions, which codified the customary law of armed conflict. The convention presumed to draw on existing state practice that derived from those values and principles deemed to constitute laws of humanity. As reflected throughout history in different cultures, after World War I, the Allies, in connections with the Treaty of Versailles, established commissions to investigate war crimes that rely on these 1907 Hague Conventions as the applicable law. In addition to war crimes committed by the Germans, the commissions also found that Turkish officials committed crimes against humanity, crimes against the laws of humanity for killing Armenian nationals and residents during the period of the war. The United States and Japan strongly opposed making such conduct criminal on the grounds that crimes against the laws of humanity or violations of moral and not positive law. The crimes against humanity, it includes murder, exterminations, enslavement, deportations, and other inhumane acts committed against civilians populations before or during the war, or prosecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdictions of the tribunal, whether or not in violations of the domestic law of the country where it was perpetrated. The Nuremberg Charter represented the first time that crimes against humanity were asserted as part of positive international law. The MIT for the Far East at Tokyo followed the Nuremberg Charter as did Control Council Law Number 11, which the Allies prosecuted Germans in the respective zones of occupations. However, no specialized international conventions on crimes against humanity has emerged, although the category has been included in the statutes of the International Criminal Tribunal for the former Yugoslavia, the ICTY, and the International Criminal Tribunal for Rwanda, ICTR, as well as in the statute of the ICC. Contemporary international documents reveals the definitions of crimes against humanity. It is differs slightly. However, it shares the idea that crimes of humanity are specific acts of violence associated with and directed towards the prosecution of a group of persons. The Rome Statute of the International Criminal Court, ICC, Each of these instruments further refined and expanded the definitions of crimes against humanity. The Rome Statute, in particular, provides a comprehensive list of acts that can constitute crimes against humanity when committed as part of a widespread or systematic attack directed against any civilian populations with knowledge of the attack. The genocide, then the crime of genocide, tracing its origins to the work of Raphael Lemkin in 1940s. Lemkin coined the term genocide by combining the Greek word genos, which refers to race or tribe, with the Latin suffix "cide", which means killing. The Preventions and Punishment of the Crime of Genocides, which has been adopted by the United Nations General Assembly in 1948, defines genocide as any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destructions in whole or in part. D. Imposing measures intended to prevent birth within the group. And E. Forcibly transferring children of the group to another group. The International Criminal Court, ICC, was established in 2002 to prosecute individuals accused of genocide, crimes against humanity, war crimes, and the crimes of aggressions. The ICC is a court of last resort, meaning that it can only prosecute individuals if national courts are unwilling or unable to do so. The ICC jurisdiction is limited to crimes committed after the Rome Statute entered into force on 1st July 2002. The ICC can only prosecute individuals if their state is a party to the Rome Statute or if the United Nations Security Council refers the case to the ICC. Piracy is presented as one of the oldest crimes of universal jurisdictions. The development of anti-piracy laws from ancient times to modern era highlighting key legal instruments. The first is 1958 Geneva Conventions on the High Seas, the 1982 United Nations Conventions on the Law of the High Sea, the UNCLOS. The UNCLOS defines piracy as A. Any illegal acts of violence or detentions, or any act of depredations committed for private ends by the crew or the passengers of a private ship or private aircraft and directed, number one, on the high seas against another ship or aircraft, or against persons or property on board such ship or aircraft. Secondly, against a ship, aircraft, persons, or property in a place outside the jurisdictions of any state. B. Any act of voluntary participations in the operations of a ship or an aircraft with knowledge of facts making it a pirate ship or aircraft. C. Any act of inciting or of intentionally facilitating an act described in subparagraph A or B. The International Convention Against the Taking of Hostages, 1979. The Rome Statute of the International Criminal Court. 1979 Convention defines the offense of hostage taking and obliges state parties to make it a punishable offense under their domestic criminal laws. The Rome Statute includes hostage taking as a war crime when committed in the context of an international or non-international armed conflict. Torture as international crimes, it is an absolute prohibition of torture under international law. The United Nations Conventions Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, 1984. The European Conventions for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, 1987. The United Nations Conventions, 1944. 1984 defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person informations or confessions, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discriminations of any kind, when such pain or suffering is inflicted by or at the instigations of or with the consent or acquiescence of a public official or other person acting in an official capacity. There are two notable human rights cases which relevant international criminal law. The first one is Filartiga versus Pina Irala, United States Court of Appeals, Second Circuit, 1980, and Pinochet case, which was decided by the House of Lords, United Kingdom, in 1999. The establishment, United Nations effort of establishing countering these terrorism activities, the establishment of the ad hoc committee on terrorism, the adoptions of international conventions for the suppressions of terrorist bombings, 1997, the adoptions of the international conventions for the suppressions of the financing of terrorism, 1999, the creation of the Counter-terrorism Committee, CTC, by the United Nations Security Council through resolutions 1373 in 2001. The limitations of CTC's approach, particularly the absence of comprehensive definitions of terrorism. It examines the tensions between the suppressions of terrorism and the protection of human rights, highlighting concerns raised by various human rights bodies about potential human rights violations in counter-terrorism efforts. The analysis emphasizes the need for the international community to agree on the basic concepts to make progress in combating the threat of international terrorism.